Hi, everyone. It is so great to be here at the Midwest Parkinson's Conference. I'm coming to you from St. Louis. Once again, we're doing things virtually. I'm still hopeful that we'll be doing things live one day, but virtual sure has been convenient because I can be here in my home and you can be in yours and we can still all be connected. So it's truly a pleasure to be here. I'm excited to talk to you about estate planning. And we're going to start with just a little bit of an introduction about me. So I am the founder and the principal attorney of the Estate Planner. We're in St. Louis in the South County area, Sunset Hills. I do estate planning and elder law. I'm all about estate planning being planning for peace of mind. And I truly believe that planning in advance is an act of love for the people we care about. And we do trusts and wills and healthcare and financial powers of attorney. We do special needs planning and long-term care planning. And we're all about protecting you, your family, and your legacy, whether it's through a disability or after death. So estate planning 101. When I talk to people about estate planning, I am always talking to people about what is your why? What's the thing that really drives you, means the most to you in your life? And as we go through this presentation, I love for my talks to be a conversation. And I know because I'm being recorded and I'm not there with you right now, you're not able to ask me questions in the middle of our conversation. But after we're done, I'm going to be there live to answer any questions you have. So please be thinking about the questions that are important to you. And so that first question when I sit down with people is, or I have a conversation or we do a presentation like this, is what's your why? What are the things that are important to you? Why do you think about estate planning? What's meaningful in your life? And so my why is, first of all, those, I don't know if my mouse can show you, these three guys. So this is my 19-year-old, my 17-year-old, and my 14-year-old. So my three boys, they're sort of my biggest why. But my other why is I love helping families and individuals take care of their families, and especially to plan for incapacity or disability and to plan for death, giving our loved ones the space to grieve and making it easier for them to cope with our disability, to take care of us, and also taking the uncertainty away from death through advanced planning. And we're going to talk about some of the things that we can do to give our loved ones that not only the space to grieve, but also the space to take care of us if we are disabled and need help. So 5 reasons you need an estate plan. So people come to me a lot of times and they'll say, Stephanie, I'm not Bill Gates. I don't have enough to need an estate plan. And I always say, every one of us has something that's important to us, whether we have a car or we have a house, we have bank accounts, some of us have investment accounts, most of us have 401ks or IRAs. So you don't have to be Bill Gates to need an estate plan. So if we have stuff, we need an estate plan. If we want to control who's going to make healthcare decisions for us and financial decisions for us while we're alive, but if we can't make those decisions, if we have minor children, we need an estate plan. We need to appoint a guardian for them. What happens to our kids if something happens to us? We need an estate plan if we want to make things easy for our loved ones and avoid, at least in Missouri, the very expensive and time-consuming probate process. And we need an estate plan if we want to guide our loved ones once we pass on how they spend our hard-earned money. So just some important considerations to think about why we might need an estate plan. So what kind of things are we planning for with an estate plan? We're planning for several different things. And one of the things, often people will come into my office and they'll be like, well, I'm planning for my death. So this is what I want to have happen once I pass away. And what I tell people is we're also planning for incapacity or disability. We're planning for who's going to take care of us, who's going to make healthcare decisions for us, who's going to make for financial decisions for us if we can't. And I think as we're looking at estate planning, when I think about the most important piece of that plan for us, part of it is planning for who's going to take care of us if we are mentally or physically disabled and not able to. So then the other piece of that planning puzzle is the asset transfer on death. What happens to us when we pass away? What happens to our assets when we pass away? Who gets those assets? How do we decide who gets those assets? So we're looking at those kinds of issues. And sometimes the assets that we're concerned about are not our bank account. That's easy to decide. We're going to split it 3 different ways. Sometimes some of the hardest assets to figure out are things like grandpa's fishing poles, grandma's knitting needles, things that may not have a lot of financial value, but they have meaning to our loved ones. And by giving them to the people who will value them, we've added significant value to somebody's life that's not necessarily monetary. So important things to think about when we're thinking about asset transfer. We're also thinking about taxes. So we're planning for taxes. Now, right now, the federal estate tax exemption is $11.7 million. So it's huge. And for those of you in the audience fortunate enough to be in that place, congratulations. But many folks are not. And we're not really thinking anymore about that federal estate tax. And when we talk about the federal estate tax, one of the things that it's important to realize, and the reason it's so important, is if we were to pass away with more than $11.7 million, each dollar over that gets taxed at 40%. So that's significant. And that level might change. There's been talk about it going down to 3.5 million or 5.5 million. So we're really thinking about planning for federal estate taxes. But we're also thinking about income tax issues. So many of us today, and I'm sure some of you in the audience have IRAs or 401ks. And the thing to keep in mind is that when we put that money into those savings accounts, that money went in free of taxes. We didn't have to pay tax on it. And when it comes out, it's not coming out free of taxes. It's going to get taxed. And so when we take it out, whether we're doing mandatory distributions or more than that, of course, we pay income tax on it. But when our beneficiaries take it out, they pay income tax on it too. And there's some super important considerations and planning issues around that, because our beneficiaries have to take that money out over an expedited time period. They used to be able to take it out over their lifetimes, but now they have to take it out for most beneficiaries, not for everyone, but for most beneficiaries within a 10-year time period. Why is that important? Let's say you inherit $500,000 in an IRA, and now you have to take an additional, $50,000 a year. It could throw you into a new tax bracket, and you're paying more in taxes than you would have been. So it's not a terrible thing, of course, to have $50,000 additional dollars a year, something to think about in terms of income tax planning. So then we also look at personal planning goals. And that's just all about, when you pass away, how do you want your loved ones to inherit? Do you want things to be divided evenly between your children? Do you have friends that you care about? Do you have a significant other you want to provide for? Maybe you have grandchildren or charities that you want to provide for. So we think about those goals as well. We're going to get to the nuts and bolts, I promise. That's just the overview of what we're thinking about. So how do you plan an estate? What are the ways you plan an estate? And the first thing that I typically ask people when I'm doing a presentation like this live is, how many of you do not have an estate plan? And lots of folks will raise their hand, right? Because they haven't sat down with an attorney, and they think, well, I haven't sat down with an attorney. I don't have a will. I don't have powers of attorney. I don't have an estate plan. But the truth is, you still have an estate plan. And why is that? That's because we have estate plans even if we don't have any documents. And I tell people too, if the only thing you take away from this presentation is that you can still do some estate planning even without coming to see me or another attorney, it's a super important takeaway. So the first thing is, even without documents, you still have an estate plan. Your assets are passing by contract. Now, what do I mean by that? So if you have a bank account and you're joint with somebody on that bank account, when you pass away, that account goes to the person you're joint with. If you have a house and you're joint with somebody on that house, when you pass away, that house goes to the person you're joint with on that house. So just important to remember, life insurance. Your life insurance beneficiary, that's estate planning with no documents. Those are just, everything is passing by contract. Beneficiaries on bank accounts, beneficiaries on 401ks or IRAs. So when I talk to people about that, they said, well, Stephanie, why in the world then does anybody go see a lawyer if I can do all of this with just beneficiary designations? And here's two important takeaways. So the first one is, yes, you can definitely and should make sure that all of your beneficiary designations on every account and every asset that has a title, like a car or a boat, we transfer those on death. You can put that on the title. It transfers on death to another person or to your trust. So you definitely can and should make sure your beneficiary designations are updated. But what happens? Why is not having documents necessarily a great idea? Well, the first thing is you're not planning for incapacity. So you're not planning for what happens to those assets if you become disabled. You're not planning for who's taking care of you. You're not planning for minors. What happens if the beneficiary of that account is a minor? All of a sudden, a custodian now has to be appointed by the court to manage that money for them. And there's no protection for your beneficiaries. There's no creditor protection, and there's no protection against bad actors. So those are all things we need to think about too. All right, so important documents to have, and we talked about this a little bit, if you become disabled. So when we talk about planning, so the first thing is we can plan with no documents. The second thing is we can plan with no documents and with powers of attorney. And those powers of attorney, so I always tell people the first starting place is making sure your beneficiary designations are how you want them. After that, we want to make sure that you've got documents in place that say what would happen if you were to become incapacitated or disabled. So essentially, we're talking about mentally disabled here, right? You're not able to make decisions for yourself. So the first and most important document that we have is a healthcare power of attorney. Who's going to make healthcare decisions for you if you can't? Next, there's a HIPAA release, a release of information. Who can get information about your health condition? There's that advanced directive, that's what we call the advanced directive in Missouri. A lot of people know it as the living will. That's the document that says if you are not going to recover, if you are persistently unconscious, what type of procedures can be withheld. And finally, there's also a financial power of attorney, and that's the document that lets people make financial decisions for you if you can't. So we're going to talk about that healthcare power of attorney first because there's some important things to think about here. So, and the advanced directive. So the first thing, that advanced directive or living will, it expresses our wishes if we're persistently unconscious and there is no hope of recovery. And it allows the person who's your healthcare power of attorney to withhold or withdraw artificial nutrition and hydration, surgery, antibiotics, a ventilator, radiation, CPR, all kinds of things. It gives your healthcare power of attorney sort of the ability to make some of those hard decisions for you. Now today in the time of COVID, and I am so hopeful that we are beginning to see the light at the end of the tunnel. But today, in the time of COVID, one of the things my clients ask me all the time is, Stephanie, I don't want somebody to be able to take me off a ventilator. I mean, what if I need one? And my response is always, no, this is not a COVID issue where a ventilator is going to help you survive and live to see another day. This is an issue where somebody's allowed to take you off a ventilator if you will just be kept alive, but you're never going to mentally recover. So it's giving the person appointed your healthcare as your healthcare power of attorney the ability to make some hard decisions for you. And then finally, with those documents, we have that healthcare power of attorney. And that's essentially the document that appoints somebody to be a decision maker for you. Who can make those hard decisions? And when I talk to people about these hard choices and what to consider when they're drafting that advance directive and when they're marking off the things that they would be willing to have withheld, I tell people several things. I say, number one, what we're doing here is we're giving our loved ones the ability and permission to make a hard decision on our behalf. And for those of you who have ever been in that place where you've had to make a hard decision to withdraw whatever it might be and allow your loved one to pass peacefully, you know how difficult it is. And so part of allowing people to make those hard decisions is having conversations about those hard decisions as well. And certainly having that conversation with the person that you've appointed to be your healthcare power of attorney. And I'm going to say one more thing, and then we'll move on to a different slide. And that is, pick your healthcare power of attorney carefully. Occasionally, I will have spouses in my office who will say directly to me, I cannot make those hard decisions. I could not withhold surgery, or I could not withhold nutrition, or I could not withhold a ventilator if that would allow my loved one to stay alive, even if they're going to be in a vegetative state. They say, I can't do that. And in that case, I say, you know, your spouse may not be the right person to appoint as your healthcare power of attorney. So the bottom line here and the takeaway is, be sure you're having hard conversations about what your healthcare decisions are, and also be sure you're having hard conversations about whether the person who you would typically appoint is the right person. So one of the most important estate planning documents you can have, that advance directive and that healthcare power of attorney. All right, planning for mental disability, the financial power of attorney. So let's say you're in the hospital and you're not able to make any decisions. You're mentally incapacitated for whatever reason it might be. We need somebody appointed to manage our finances. And this is the person who's going to sign checks, manage our bank accounts, and pay our bills if we can't. This is the person who we trust to do the right thing for us. And this is the person who we've talked about, hey, if something were to happen to me, here are the people who I support. Here's my loved ones. Here's the people I help take care of. Here's the pets I need provided for. So some of those conversations with our financial power of attorney. Sometimes our healthcare power of attorney and our financial power of attorney are two different people, because the person we want making healthcare decisions for us and the person we want running our finances are not the same. Sometimes they are. It kind of depends on our loved ones and our family. All right, so back to some bigger, more complex documents. And the first one I'm going to talk about is a will. So essentially, at least in Missouri, and many states are like this as well, a will has to go through probate. When I do a will plan for somebody, what I am typically doing is a power of attorney plan and beneficiary designations. And the will is used if somehow something's gotten forgotten. Some asset has been forgotten, and now that asset has to go to probate, through probate. But the main takeaway with a will is it must go through the probate process, and it appoints guardians for kids. So it's a formal document that tells the probate court who gets our assets, and appoints a personal representative for our estate. And of course, the disadvantages: must be filed with a probate court, may be time-consuming and expensive to administer. It is a public document, and there's less flexibility than planning with a trust. So when I do a will plan, I talk to my clients about this essentially being a beneficiary designation plan and a power of attorney plan. Then the will is just picking up something that we forgot to get a beneficiary designation on. So the kind of planning that I typically do for people is trust planning. And a lot of times when folks first come into my office, they say, Stephanie, what is a trust? I mean, I'm not a trust baby. I don't. And some people, of course, are very familiar with trust. It just kind of depends on your own family and personal situation. But essentially, what is a trust? And I use a treasure chest because it helps materialize what a trust really is. But a trust is essentially a treasure chest with a map in it, and the map really is the contract that is the trust, and the treasure chest is all of our assets that we put into the treasure chest that are governed by the trust. So essentially, after using that picture to give us an idea, a trust is essentially a signed and notarized contract that holds our assets, and it instructs our trustee how to handle those assets if we're incapacitated and after we pass. And that trust, and here I'm talking about a revocable living trust, and we're not going to get into the more complex irrevocable trusts and asset protection trusts today. We're going to kind of stick with the basics. But that revocable living trust tells our trustee how we want our assets used while we're incapacitated and how we want them distributed after we pass. And there's all kinds of flexibility when we're figuring out how to distribute assets when we pass. And the important thing to realize with a revocable living trust is that it is, while we're alive and well, we do whatever we want to it. We change it how we want, we revise it, we amend it, we change beneficiaries, we change trustees, and the assets that are registered in the name of the trust are treated just like our assets for every other purpose. They're reported on our income taxes. It's almost like the trust doesn't exist, but yet it does, and it's going to step in on our incapacity and at our passing. So some of the advantages of a trust: lots of flexibility, allows our chosen helper to manage our finances if we're mentally disabled, no need for probate court intervention, it's private, it's an easy way to distribute our assets when we pass. There's some creditor protection, especially in Missouri for spouses, which is a more complex question for a different day, but an important point for some people. And then there's lots of ways to control distributions to our beneficiaries. So some super important points when we're looking at trust planning and the advantages of trust planning. All right, and so that's where we're thinking about a trust. And one of the things that I really talk to people about is, and I have younger folks come and I have older people come, and everybody says to me, Stephanie, why do I need an estate plan? And there's all kinds of reasons why people think that they don't need an estate plan and they don't need any estate planning. By the way, this is a picture of me and my 3 boys again, and we're in the mountains. Nobody else will let me use pictures of them on these slides, and the boys are hesitant, but it's just the point I make with this slide is just, when we're planning for our families, it's really never too early to plan. We want to plan early, and my son, for example, is 19. He does have a healthcare power of attorney and a financial power of attorney. Not a will yet because he has 1 bank account, but I want to be able to make healthcare decisions for him if I needed to. And once our kids are 18, parents cannot necessarily make decisions. So 18 is not too young to have some kind of a plan in place, certainly to make sure your young adults have beneficiary designations on accounts. And then as we get into our 20s and 30s, of course, we're not thinking about planning at all, but it's important even then to start thinking about planning, especially once we have children. So super important to especially be planning for our minor kids. And then even as we get older, we're in our earning ages, life is good and well, and yet things happen. And of course, as an estate planning attorney, I see it all the time. Unexpected illness, unexpected accident, things happen. And if we haven't taken the time to make advanced arrangements, then our loved ones may be left in a situation where they can't reach our assets, they don't know where our assets are, they don't know what our wishes are, and so there's just some important planning at all stages. And then, of course, as we get even older, unfortunately, leaving this planet becomes even more likely than it does when we're younger. But then we're also starting to think about not only sort of the basics of planning and the legacy we want to leave, but I tell my clients, and I tell my younger clients this too, but I tell my clients, we're not only thinking about that formal estate plan and the powers of attorney, we're also thinking about making sure that we've left our loved ones enough information to plan easily for our death. So what kind of ceremony do we want? By letting people know that, we give them the space to grieve. We want to let people know how to get to our accounts and where our accounts are and what assets we have. So I'm talking kind of about a when I'm gone file. And then also, we want to be sure that we've had some of those very important conversations with people, whether it's passing on a recipe or telling somebody you love them or letting somebody know that they were meaningful in your life. And you can do that even by putting love letters in that when I'm gone file so that people can look at those after you die if there's something that you wanted to share that you weren't able to during your life. So just some things to think about, but the bottom line is really never too early to start planning. And of course, I'm going to end on this kind of sad slide, but it can be too late. And when is it too late? It's too late to plan when we no longer have the capacity to plan, when we no longer have the ability to make decisions, when an accident has happened or when we pass away unexpectedly, or even frankly, people pass and they've been expecting to pass and they still just weren't able to make the time to plan. Just so important to remember that we think we have all the time in the world and sometimes we just don't. So never too early to plan, certainly can be too late. It has been such a pleasure to have the opportunity to be here and talk with you. I hope some of this has been helpful. I hope you got some information that you can use. Mainly, make sure you have beneficiary designations, get those powers of attorney done. We're happy to help with wills and trusts and powers of attorney. We do an initial intake for free of charge. And we're here in St. Louis, so you're welcome to look for us. But any estate planning attorney would be happy to help you with those needs. And just important to sit down and have some of those conversations, not only with a professional, but with our loved ones. And with that, I hope you have some questions for me. I'm really open to whatever they may be. I love having this be an estate planning conversation. And just look forward to hearing from you. So hi, everyone. Oh my goodness, it's nice to be here live. And I hope you have some questions. So I will kind of wait and give it a minute or two to see if we've got some questions. Oh, wow. Great question. So the question is, my parents never talk about their estate plan with me. How can I break the ice? I love this question because this is sort of that when I'm gone file question, and it's also the how to have hard conversations question. So the first thing I tell people, and I know the person who asked this, you're not thinking about what you're going to inherit. You're thinking about how to help your parents kind of plan for the future. And so the first thing that I tell my clients to do, if you're afraid your parents haven't done any estate planning or you're concerned about whether they have, I would start talking about some of the things, your favorite memories with them, and that you would really be sad if they passed away. And so I use my grandma's jelly recipe example. So I'm gonna give this silly example, but my grandma made the most amazing elderberry jelly that I've ever had in my life. And I learned how to make that jelly with her. She and I sat down and we learned how to make it. And I don't have the recipe for it. And she passed away, and I tried to make it. I tried to make that elderberry jelly, and I ran into a brick wall because I had no idea where she got her elderberries or how to get those elderberries. And she lived in a small town in the Ozarks in Missouri, and she got them from a friend on a farm somewhere, and I cannot replicate her elderberry jelly. So now, why do I tell you that story? So it's a close connection like that, where you can say something like, this is some of the things I love that we do or that you've done, and it would be so meaningful for me to have that recipe and know how to make it. And so you're sort of making a connection, and then you're saying something like, it makes me think about what would happen when you pass, and I want to know that you have you've shared some of those recipes, or we've shared some of those recipes, or some of those, maybe it's where your favorite fishing hole is, or whatever it might be, and you've used that personal connection to segue into, I'm concerned about what would happen on your passing, and I'm concerned about what would happen if you were incapacitated. And the big question is, Mom or Dad, I want to be sure your healthcare wishes are met. I want to know what those wishes are. And so I always recommend breaking the ice with like this. With me, it would have been grandma's recipe, but not just the recipe. Where do you find those elderberries? And then you use that loving connection to segue into, I think, a broader conversation about healthcare wishes. What's going to happen if you're incapacitated? What do you want? And then you can move on into bigger estate planning issues as well. So that's what I recommend. And I hope that helps. All right. So do I need to have a minimum amount of money to have a trust? That is a fabulous question. And the truth is not really a minimum amount. Now, trusts are not inexpensive. It does cost something to set one up. But the truth is that it really depends on the family situation. So for a family with young children, we want to be sure mostly that somebody has a trust set up so that if they were to pass before the children are of an age of majority, then we want to be sure that that they're going to be taken care of, and we want a trustee to kind of distribute assets for the kids' needs. So when I'm planning with the trust, I'm not really looking at how much you have in assets. I'm looking more at what your needs are. So great question. Great question. So we're looking at needs, not necessarily at assets. Do we help facilitate some of the difficult questions if people can't make a choice? So yes, we do help facilitate some of those decisions, and we'll sit down with our clients and we'll talk about kind of what the different decisions mean, and we'll sit down with family members and talk about that. We'll have generations meetings so that we've got multiple generations in a room talking about what people want. Those are hard conversations, and sometimes it's more than one conversation. Sometimes we need to sit down with somebody for longer than it needs to be more than once. We need to talk about what that healthcare, that advanced directive means. We need to talk about a decision maker, and then we'll talk about it again and maybe talk about it again. And the thing that I say over and over to people is have those conversations with the people that you have identified to make decisions for you. And remember that if you don't have the capacity to make a decision, the loved one who you have chosen to make those decisions on your behalf is making that decision with all kinds of information that you don't necessarily have. And so you've kind of appointed a loved one to sit in your place and make some hard decisions, but definitely more than one conversation. So a great question, is there a timeline after you create a trust for it to be legal? So what's the timeline for after we create a trust for it to be legal? So the bottom line is a trust is a legal document, at least here in Missouri, which is where I practice, after you sign it. Once we draft that document and you review it and you come in and you sign it and we have it notarized, it is a legal binding document. The problem is that trust is meaningless. It's that empty treasure chest until you actually title assets into the trust or you make assets pay on death to the trust. And what do I mean by that? So for example, take your house. Let's say you want to put your house in your trust. Well, we would warranty deed the house to your trust. And once that warranty deed is filed, then the house is in the trust. So for an investment account, if you're working with an investment advisor, once you've signed the trust and it's been notarized, then when you talk to the investment advisor, we'll say to your investment advisor, we're going to put that investment account in the name of the trust. And so now that our trust has some assets, it has our house, it has our investment account. There's some accounts that can't go into the trust right away. Some of those accounts, so for an example, an IRA or a 401k, that has to stay in an individual's name. And then typically we might have our spouse as the beneficiary after we pass, and then the trust might be the beneficiary. So that asset is controlled by the trust, perhaps after our spouse passes. So kind of a different timelines for when assets get placed in the trust, but the trust is effective once it's signed. So no real timeline. All right. So I am an only, so this is a great question because lots of people are in this situation. So I am an only child and single. Who should I designate to take care of me? So, and I'm assuming what you're wanting to know is who should you designate as your healthcare power of attorney, and who should you designate as your financial power of attorney? So that's a great question. I have lots of clients that are in that situation. So if you have parents who are still living and they're not terribly older than you and they're in decent health, you might consider designating your parents. If you have a good friend or a loved one that you can designate, that's okay too. And then there's also professionals who, there are banks, and then there are social workers, and there are people who their profession is to work as a healthcare power of attorney and as a financial power of attorney. And you want to be careful when you hire somebody to fill that role for you. You want to be sure that you're getting recommendations from other people and that they've been vetted by others, because it is possible, our healthcare power of attorney and especially our financial power of attorney, we give them broad powers. And so the selection of that person is really a very crucial decision. And so for my folks who really don't have somebody who they could designate, we look to professionals to do that. But we're careful, very careful and cautious in that selection. And I would consult with more than one professional, and I would get recommendations, and I would also talk to somebody else who has worked with that person. So good question. So another great question. People ask this all the time. So if I have a living trust, do I also need a will? So I tell people when they ask me this question, I'm like, lawyers. So I've got suspenders on. You can't see them, but I've got suspenders on, and I've got a belt on, and my shoes are double knotted. And what am I saying? We want to have all of the bases covered. So ideally, your revocable living trust is going to handle everything. We've got all of your assets titled in the name of that trust or pay on death to that trust, and everything's taken care of, and it's going to be smooth and beautiful, and we haven't forgotten a single thing. Unfortunately, occasionally, my clients will forget an asset. And so maybe it's a life insurance policy that they got when they were 22, and they've forgotten about it, and the beneficiary on it is no longer living. And so we have that will to handle things like that haven't been titled in the name of the trust or pay on death into the trust. That will is I consider the will to be the double knotted shoes, right? It's picking up an asset that for whatever reason didn't get titled in the name of the trust, and it takes that asset. We call this a pour over will. It takes that asset and it goes through probate, and it gets poured right back into the trust so that the trustee is handling the distribution of that asset. What I tell my clients when they come in and we do a revocable living trust for them, I say, look, our goal, I'm going to have you sign this pour over will, and we're going to go through the motions and we're going to have it. But our goal is to never use that will. I don't want you to use it. I want us to get all of your assets titled in the name of the trust or pay on death to the trust. And the other thing I tell people is, look, let's say you just do a will plan. All you need is a will plan. You don't have children that you're worried about taking care of. Maybe you have one friend that you want your assets to go to, and they're an adult, and you can just do a beneficiary designation. And maybe a will plan is the right plan for you. So what I tell people in that situation is, okay, I'm drafting this will for you because I want you to have the will. But really, I don't want to use that will. That will's got to be filed with the probate court. It's going to be expensive. It's going to be time consuming. I really don't want to use that will. I want you to get beneficiary designations on all of your accounts so that they pass by contract. And the will is sort of there as that double knotted shoe just in case something's been missed. Okay, can I prepare my own will and figure out a plan all by myself? No, you need a lawyer. And I say that facetiously. Obviously, it is in my best interest to say you need a lawyer. But I will tell you that it really, yes, could you go online and do LegalZoom and prepare the documents? You could, but there's some hoops that need to be gone through to make sure those documents are right. I really think it's important to sit down with an attorney and talk to them and talk about your assets and figure things out. Even drafting a trust, just kind of figuring out what makes the most sense for you. I think it's really important to have some counseling. So it's just this idea that let's talk to somebody professional. It's kind of like using WebMD to diagnose yourself. Yes, you can, but is that the best way to go? I don't think so. I mean, I think we all benefit from professional advice. But you got to keep in mind that that's sort of in my best interest. Okay, last question. Who should have a copy of my documents and where should I keep them? I want you to keep those documents in a fireproof safe, and I want your trustees to also have a copy. So just kind of keep the documents available and make sure your trustee has a copy as well. and talk to your loved ones about where they are. So what a pleasure. It's been so great to be able to answer your questions. I'm glad you had some great ones. Just an honor to be here, and I hope you enjoy tomorrow as well. And of course, we're here to answer questions if you have others as well. So a true pleasure. Thank you.
Hi, everyone. My name is Jenny Johnson, and I'm the Executive Director of the American Parkinson Disease Association Oklahoma chapter. And on behalf of everyone at APDA, I want to say thank you for joining us for the 4th Annual Midwest Parkinson Congress, hosted by the Greater St. Louis, Midwest, and Oklahoma chapters. Remember, there are even more great speakers tomorrow, so don't forget to tune in from 10 a.m. to 1 p.m. Central Standard Time. We're so excited that we're able to share all of our wonderful and knowledgeable speakers with you. We hope you're able to learn something new and to feel more empowered in your Parkinson's journey. I want to thank our sponsors who have helped make the Midwest Parkinson Congress possible. Let's all give a big thank you to our champion sponsors, the James and Allison Bates Foundation, the JCA Charitable Foundation, and Synovian. And I'd like to also thank our collaborator sponsors, AbbVie, Acadia Pharmaceuticals, Adamas, Boston Scientific, Delta Dental of Missouri, and Kiowa Kirin. I hope you're able to visit our sponsors page to learn more about how they support our Parkinson's community. Be sure to check them out. Once again, thank you so much for joining us today, and we look forward to seeing you again tomorrow. Have a great rest of your day.